Good evening. This is Rahul Magan here as a second year law student. Often people asking me that, you claim that you are a second year law student and you are making videos on PMLA, which is Prevention of Money Laundering Act. Ladies and gentlemen, you please should not forget that second year law student is a current designation. Previous to that, I worked as a corporate registrar for American companies for more than 10 years, whereby I handled not only the front office desk, but also the non deliverable forward desk, and whereby I interacted with almost all top financial institutions, mutual funds, and all. Majority of the people who even do not understand the difference between deliverable and non-deliverable, and I dealt with non-deliverable forward to the tune of 120 million US dollars on a monthly basis with banks who are based out in United States and Singapore. Henceforth, ladies and gentlemen, my understanding of tax havens, the banking relationships, how the money moves from one country to another, the basically what is private banking and all is much beyond what is mentioned in the acts. On time to time basis, I raised my voice that the time has come when the acts to integrate with the real dynamics of the banking. But in any case, this is beyond my jurisdiction. I can only request the legislator to make it happen. Today, I would be bringing a very important topic before you, and that topic is nothing but CrPC 319. Ladies and gentlemen, I repeated this many times, and I would continue to repeat till the last day of your life, of my life, which is when it comes to finance, the best way to study finance is via Reuters, Bloomberg, the business newspapers, the magazines, and all these things. And of course, the expensive books on finance which are available on Amazon and different websites. Now, why I'm using a word expensive books? Because these expensive books will give you the architecture of the variety of instruments which, if you are thinking, you get on the internet, or basically in a very layman parlance, it's fairly impossible. And when it comes to law, the scene is more or less same. Having said that, there is one beautiful thing which is coming up in the law, and that is called the citation, which is called the binding precedent of the law. Ladies and gentlemen, India also having a similar provision like many countries, which is called binding precedent. If I speak in a civil parlance, then this is called res judicata. Nothing but Article 141, read with Article 142, read with Article 144, and in case Article 145 of the Indian Constitution, which precisely means the law of land. Supreme Court of India is termed as the final interpreter of any act, any proviso, any section, or even an explanation mentioned in that section. This falls under the jurisdiction of Honorable Supreme Court of India. Henceforth, if you are practicing in law or if you are learning law, then it is paramount for us to have as maximum as judgments of Honorable Supreme Court of India. And we should be thank you to Honorable Supreme Court that now they are having their fresh website. And in this fresh website, even if you click a tab called Judgment, in this tab you just select the month or maybe whatever time duration you wish to select. and you would get all citations delivered by honorable lordships during this point of time. Some may be criminal, some may be civil, some may be arbitration, some may be taxation, and so on and so forth. This is one of the unique features Supreme Court is coming up with. Apart from that, ESCR is already live and it is running. Anyways, I am really thankful to Supreme Court for having a new and wonderful website, because now I just click the period and I download my judgment, and this is very fast as compared to the earlier one. CrPC 319 is a very important section as far as the CrPC is concerned. We all know that CrPC stands for Criminal Procedures. And it is a procedural law, which means that all those who are committing offense, basically criminal offense, to prosecute them, there is a procedure, and that procedure is given by the stat. And that procedure is known as criminal procedure. Ladies and gentlemen, I feel that Indian Evidence Act should be read with CrPC, or alternatively speaking, CrPC should be read with the Indian Evidence Act. So, even if you are doing the reading of the bare act of Indian Evidence Act, you should have a bare act of CrPC with you, and vice versa, because both are linked. So similar case is with civil also. So if you are reading CPC 1908, then it is advisable to have Indian Evidence Act also with you, because both are interlinked. Now, this is the bare act of CrPC, which is the criminal procedure. I completely respect that now the government amended not only the Indian Evidence Act, the CrPC, but also the Indian Penal Code. But having said that, the notification is yet to come. We are not sure as and when the government feels that notification to come, but when the notification would come, then definitely from whatever date the government would be mentioning, all the cases would come under the jurisdiction of new laws. So, for the time being, the old CrPC, IPC, and Indian Evidence Act are in action. As simple as that. When the new notification come, then definitely we'll have words in that regards. And of course, I'm keeping an eye on that. My interpretation is very clear that CrPC 319 is one of the amongst most important provisions we are having as far as the criminal procedure laws are concerned. I repeat, criminal procedure laws. Let me do the bare reading. Section 319 say power to proceed against other person appearing to be guilty of offense. I repeat, power to proceed against other person appearing to be guilty of offense. Kindly note that the word cognizable is not mentioned in the heading. I repeat, the word cognizable is not mentioned in the heading. Now, first of all, let's go to subsection 1, where in the course of any inquiry into or the trial of an offense is appears of an offense, it appears from the evidence that any person not being the accused has committed any offense for that which such person should could be tried together with the accused. The court may proceed against such persons for the offense which he appears to have committed. So suppose there is any offense which is done by one person or set of person. And when this offense was done, suppose the offense is done by 1, 2, 3, 4. The police frames the charge sheet, the first information report against 1, 2, 3, 4. But having said that, at later point of time, note the word appears from evidence. Now, when I'm stressing on a word appears from evidence, now Indian Evidence Act 1872 respective amendments come into the action. And we need to delve down into Indian Evidence Act 1872 to see what sort of evidence we are holding. Are we holding oral evidence? Are we holding documentary evidence? Are we holding hearsay evidence? Or we are holding some other form of evidence? So example, 1, 2, 3, 4 committed a crime. And fifth, who was at initial stages of the FIR or when the FIR was registered under 154, his name was not mentioned. So common sense, if his name is not mentioned, his name is not mentioned in the charge sheet also. Now in this eventuality, what happens that at a later stage, note the word in the course of any inquiry, there is a video which is coming before the court. And that video is showing that the party number 5th is also a party on the grounds of abetment. Abetment means he is instigating. He was trying to instigate all four to commit relevant XYZ crime. Now that evidence is an electronic evidence, which means a video. Of course, Indian Evidence Act section 65B comes into the picture and respective norms comes into the picture, and the Honorable Court needs to agree that this video prima facie is showing that party number 5 was part of the crime, but that party was not mentioned in FIR and also the charge sheet filed by the police under 173. I repeat, where in course of any inquiry into or the trial of an offense, it appears from the evidence. So, the most important thing which comes under section 319 is nothing but the evidence. So, it can't be like that you can make anyone as a party. You are supposed to have a very strong evidence come into the picture. Ladies and gentlemen, in this video, I am deliberately not discussing the 3 important sections of Indian Evidence Act. Number 1, the section 3. Number 2, the section 4, read with section 5, section 56, and most important, section 136, read with 165. I'm not saying that other sections are not important. Other sections are also important. But having said that, section 3, section 4, section 5, read with section 56, read with section 136, read with 165 is having a direct relationship as far as 319 is concerned. Other sections are also important. If we go with subsection 2, where such person is not attending the court, he may be arrested or summoned as the circumstances of the case may require. Any person attending the court, although not under arrest or upon a summon, may be detained by such court for the purpose of inquiry into or trial for the offense which he appears to have committed. Ladies and gentlemen, 319 is a very comprehensive section, and very soon we are coming up with a judgment piece also. Where the court proceeds against any person in subsection 1, the proceeding in respect of such person shall be commenced afresh, which means from the start, and the witness reheard. Now, when I'm using a word witness, then I'm referring to three things: examination in chief, cross examination, and re examination. Examination in chief, cross examination, and re examination. Subject to the provisions of Clause A, the case may proceed as if such person have been accused person when the court took cognizance of the offence upon which inquiry and trial was commenced. In this eventuality, I downloaded the 4 citations of Honorable Supreme Court of India. Number 1 citation is SCC 2019 4 SCC 342. Number 2 is 2018 14 SCC 51. Number 3 is 2019 6 SCC 368. And number 4 is 2019 7 SCC 806. Soon, I would be bringing you the comprehensive analysis of all 4 citations by Honorable Supreme Court of India. And since these citations are from Honorable Supreme Court of India, henceforth they are the binding precedent under Article 141. Ladies and gentlemen, please remember that when you are reading the Bare Act, you should refer some commentary. More importantly, it is paramount to see the respective binding precedents of Honorable Supreme Court. Very soon, we are coming up with another video of Section 319. And in this video, we would be covering more topics as far as 319 is concerned. Thank you.